Good afternoon. We are going to review material from Chapter 2, Basic Principles of Real Estate Law today. The PowerPoint slide that I will be going over is found in your materials for this first week of the class. If you have any questions or concerns about Chapter 2 or Chapter 1, please feel free to email me, or we will, of course, talk about any questions that you have at the top of our class next Tuesday. But if you have questions, please feel free to email me. Also, remember that your census assignment is due, and that is your course entry assignment, is due by the beginning or by 11:55 on Friday the 16th. So you want everyone, please make sure that you complete your census assignment so the material for this week will be released, and that you submit all of your assignments that are in module number 1. And so to begin our lecture for this afternoon, I want to talk about what is property. Before we start talking about the classifications of property, what is property? Property is everything that is subject to ownership or possession by someone. It is any and everything that is subject to some type of ownership or possession by someone else. And when you think about property, there's basically two types of property. There is in what property as a whole is. It's either going to be intangible or tangible. Tangible property is something that can be held, something that can be touched, right? That is tangible property. While intangible property is property which has no intrinsic value other than what it represents. So, for example, a stock certificate is an example of intangible property because a stock certificate is just a piece of paper. However, its value is in what it represents, right? So you can take that stock certificate, and that stock certificate has value. Another example of intangible property is a check. Okay, a check has in and of itself has very little value. However, you can use that check to purchase goods and services. So that is what property is generally. And so you have what personal property is, okay, and the classifications of property. Real property. Real property is land and all things that are permanently attached to the land. So it is land that everything affixed to that land, everything that is permanently attached to that land is considered real property. Okay, and so some of the characteristics, some of the important characteristics to remember about real property is that, first of all, real property is scarce. There's never going to be any more real property created. And so what we have now is all that we're ever going to have. Real property is also tangible, meaning that it can be touched, it can be felt, right? Real property is going to include buildings, it's going to include acreage, natural objects that are coming out of and from the land, items of personal property that are permanently affixed to the land are now real property. Those are fixtures. All of those things are considered real property. And real property, unlike personal property, is transferred through deed. So the ownership to real property is transferred through deed. Conversely, personal property is any movable asset other than real estate. So any movable asset other than real estate is personal property. So in the example of the check or the banknote, both of those things are personal property. They are intangible pieces of personal property because even though they have no intrinsic value, they still can be movable. Those things can be possessed by someone else. And so they are considered personal property versus real property. And so you have And when you look at the overall property in terms of what property is, we know that property can be either tangible or intangible. Then the two types of property is either real property or personal property. Okay, and so let's break it down even further. Within real property, there are classifications of real property, the different types of real property. And so when you think of the types or classifications of real property, you're going to have surface rights, subsurface rights, mineral rights, and air rights. All of those are classifications of real property. Surface rights, subsurface rights, air rights, and mineral rights, classifications of real property. Your book does go into detail about them, and it's important for you to understand the distinction or the differences between the different types of property. Okay, and so what are land are surface rights? When you look at surface rights, you're talking about, of course, anything that's on the surface, and that would be the actual land. And then water is on the surface. You can see that with the natural eye. Okay, land rights are those defined by specific boundary lines. So when you're talking about the land rights, those are property rights in land that are defined within a certain boundaries, and it is incorporated into a legal description. Land rights will again include any type of um, fixtures or things that are growing out of the ground. Those are all land rights to property. And then we have water rights. Water rights are very important, as is all rights, but water rights are important because you by looking at water rights, they are important when you're trying to assess the value of a piece of real property. Okay, water rights are rights to property that is covered by water, or or a piece of land that is adjacent to water. So it is water rights cover property that is covered by water, or the land that has property that's adjacent to a body of water. That is what, when you're talking about water rights, that's what you're talking about. Okay. And so there are some subcategories of water rights that the book discussed. One would be groundwater, okay, rainwater, surface water are types. When you think about the water rights and the study of water rights, um, you want to look at the riparian doctrine. The riparian doctrine is premised on a common law principle, a common law theory that citizens should share water rights equally for their daily needs. Okay, it is a system for allocating the use and possession of water among those who own the land along its path. So the riparian doctrine basically put things in place for those who live along the water line to actually have use and enjoyment of that land, and no one excluding others from that use. The idea is that people should share water rights equally. Okay, and so under the riparian doctrine, you have littoral rights and riparian rights. Littoral rights are the right to use water up to a high water line or lake, ocean, or sea, and riparian rights are when you consider what is navigable or unnavigable water, and when you are looking at determining rights. Our littoral rights are going to be relate to an owner whose property abuts a lake, ocean, or sea. The owners are going to have access and use of the land up to the high water mark. Riparian rights, on the other hand, pertain to a landowner's landowners' use of property that abuts a river, stream, or other watercourse. To determine the extent of ownership, must determine if the water is navigable or not. Can a boat navigate that water? So that's how you look at that. Both of these are common law old doctrines, but they're still on the books today. The appropriation doctrine is a system of water rights that gives an individual the right to use a qualifiable amount of water. The right to use water is prioritized on the basis of the date the use was established. Now, again, that's another common law principle about that deals with water rights. And so you have their subsurface rights and your surface rights. I'm sorry, your surface rights. And among your surface rights, you have the right to the land. Then you have the right to water. You also have air rights. Air rights are um, the landowner's ownership of the airspace above the land up to heights that are established by law. So when you want to consider the air rights that you have, you want to look at the relevant law of the state in which the land is located to determine how far up the air rights go. And generally, they go up until a point to where airplanes actually fly, or whatever that distance is, right? So, and a lot of people don't even know that, we do when property is transferred, you do have rights to the air that is above that property. Air rights is very important when you're talking about condominiums, because condominiums are up to a certain point. So all of those things, air rights are also important for folks who have beach properties or who like views of property. And so that's why when air rights become an issue and when air rights is something that would be considered, but our property do have, they come along with air rights as well. So then subsurface or mineral rights. That is another right that comes with real property. Uh, Subsurface or mineral rights involve a landowner's right to extract the minerals from below the surface of their land. So you can have a deed to the land, and you can also have a deed to the mineral rights or subsurface rights. You can also even sublease out your right to subsurface or mineral rights to others. A lot of people do that. They may find natural gas, or they may find other things under oil. One the a common old school sitcom was the Beverly Hillbillies, where they found oil on their land, and so they became millionaires as a result of that. They still stayed on the land, but they gave someone else the right, I'm sure, to actually get that oil off of the land, and so they gave them a type of deed to actually drill and that type of thing, right? And so it deals with the owner's right as that relates to his or her ownership of the property to extract minerals from the land. It is the right that extends from the surface boundaries downward to the center of the earth. So even when you talk about subsurface rights or mineral rights, it is not infinite, right? It's going to go from the surface or the top down to the center of the earth. Subsurface rights can be worth more than the actual house or land itself, especially in the example if you find some type of natural mineral or something like that on the land. The subsurface or mineral rights can be valued more than the actual land. And as I forestated, those rights can be sold or leased, and the ownership of the underlying land still remain intact. All right, personal property. talked a little bit. So we talked about real property, so now the different classifications of personal property is that, again, it's movable, but it is transferred by a bill of sale. Okay. What that means is that when an interest in personal property is transferred, there's no deed involved. Okay. It is transferred either by a bill of sale or a receipt. Okay. May require addition. It may require a UCC financial statement as well, which is going to govern commercial transactions. You often do see UCC financial statements on large items that become fixtures. On the property. And what a UCC financial statement is that it gives notice from a lender to any third parties who search the title that there is a item of personal property on the property, or that's owned by the property owner, that has not been paid for. And so that lender then has a perfected security agreement or interest in that property for the amount of the personal property that is covered by the UCC. Okay, an additional classification of property is fixtures. A fixture is an item of personal property that is physically and permanently attached to real property. That's what makes it a fixture. It starts again as personal property and it becomes real property when it is permanently attached to the real property. Unless there is an agreement, a fixture cannot be removed and is perpetually a part of the property. So unless there's an agreement between the seller and the buyer, fixtures must remain on the property because they are now a part of the property. See here that a fixture is an object that at one time was personal property, but that has, through the process of attachment to the real property, become a part of the property. So when you want to determine if something is a fixture, it's important to look at the underlying contract, the contract of sale, to see what items are going to go along or to be transferred along with the land. Another example of a fixture would be a shed that is purchased at Home Depot or something like that. Generally, unless there is some type of language in the contract, the shed is a fixture, it stays, it becomes a part of the real property. However, the buyer and seller do have a right; they can negotiate, and to such extent that the shed does not become a part and it can be removed. That's important. Um, Paralegals, in terms of the roles of paralegals actually, when you're looking at um, offer to purchase contracts, when you're looking at title searches, it is important to do UCC financial statement. Look for those in your title search to see if there's anything that's going to attach to that land. Also to look at fixture provisions in the any transfer documentation to inform the client of any type of provisions, and drafting fixture provisions for deeds and that type of thing, where it says what is going to be included with the purchase transaction. And discussions about a fixture can be included that is going to stay with the land. Okay, there are basically two types of fixtures. You can have a domestic fixture or a trade fixture. What's the difference? A domestic fixture is installed by residential tenants or for residential tenants and is included in the lease premises. Okay, you want to look to your state law to determine what happens at the end of the tenancy. So it is installed by residential tenants, anything that the residential tenant installs in the property. When you start talking about rental agreements, rental contracts for renting homes or apartments of things of that nature, it's really important to look at your lease agreement to see what, if anything, the tenant can install in the property. Sometimes the leases, most of the time, the leases will say that the tenant cannot install anything of permanence um, without consent. An example of that would be, for example, like let's say a tenant wanted to install hardwood floors. Okay, the hardwood floors in it of themselves would be personal property, right? Okay, but once those hardwood floors are installed into that leased premises, they become fixtures, a fixture. Okay, now would it be practical for the landowner or the landlord to require the tenant to bust up those hardwood floors at the end of the lease? Absolutely not. That is why it's important any type of major modifications that are made to a property such that's being leased, such as that, should be discussed and agreed upon by the landlord in advance. So we have domestic fixtures and then we have trade fixtures. Trade fixtures are fixtures that are installed by commercial tenants, and these can, remember that domestic fixtures, not so much, but trade fixtures can be removed. They can be removed unless there's a provision in the lease that says otherwise. A common example of a trade fixture would be like the end caps and the equipment or the merchandise that the seller installs to hang merchandise. Those things, because they have to be permanently affixed. Those things are fixtures. They're trade fixtures, but oftentimes when the buyer leaves or the tenant leaves, they take those things with them. Okay. So you have domestic fixtures and trade fixtures. Remember that a fixture is a type of personal property that becomes real property because of basically how it is used and how it is affixed to the property. When you look at how the courts look at fixtures, there's a judicial test. And this was some case law a while back, which is going to determine if a personal property is a fixture. And that judicial test basically looks at how the property was used and the intent of the parties at the time that the property was installed. Okay, so here again we have the intention of the parties, the method that was used to attach the property, how the property is being used, the relationship of the parties is also something that is considered when you think about if something is a fixture or not. So here again, we have the domestic fixture versus trade fixtures. With both of these, you want to make sure that you look at your state statute, and you also want to make sure that you look at your lease agreement. So you want, and then again, that is something that the paralegal is really good at in terms of drafting those things and reviewing those clauses for clients with the assistance, of course, of the attorney. So we never want to violate those rules. Okay. When when property is acquired, um, there are basic rights or ownership rights that go with property. So anytime you have real property, there are certain ownership rights that go along with that property. For real estate, the basic rights of ownership, and these are called or considered the bundle of legal rights. Um, the uh, the possessor of this or the owner of the real estate has the right of disposition, meaning they have the right to occupy the property. No, I'm sorry, they have a right to transfer ownership of the property to another. That's the right of disposition. The right of use is their right to the quiet enjoyment of that property. Right of possession is the right to occupy the property in privacy and in exclusion to others. So the right of disposition deals with the owner's right to sell or dispose of the property how he or she sees fit, as long as it's not for the commission of a crime. The right to use that property, being free to use that property, free of the interference of others, as long as there's no crime. The right of possession, meaning to exclude others from actually acquiring possession of the property or entry to the property. The right of exclusion, the right to be able to exclude others as it relates to that property. The right to exclusion also deals with the right to control the use of others as it relates to that property, to your property. And so then we talked about the classifications of property. We talked about the types and subtypes of property. We talked about the distinction between personal property and real property. Talked about the classifications of real property and some of the classifications of personal property, how both can be transferred. Personal property is transferred through bill of sale or receipt, whereas real property is transferred through deed. So how can you acquire real property? How is it acquired? Okay, how is it acquired? Easily, in terms of personal property, how is it acquired? You acquire it by going to the store to pick up something or someone giving you the thing. So how do you acquire real property? First way, the most common way of acquiring real property is through the purchase of the property. Through the purchase. It is the most common, and it is completed through a contract to purchase and a deed. So when real property is acquired by purchase, it is accompanied with a contract to purchase and a deed. Okay. Um, and so the deed is something that is signed by the seller to the property and is recorded in the county register of deeds in which the property is located. Another method or way to acquire real property is through devise or descent, which is basically through inheritance. Okay, it is passed from one person to another in a will or by intestate succession. It could be also passed through a trust. So some type of estate planning, some type of estate process. So you have purchase, you have devise and descent. Basically, there's a will, there's a trust, there's some type of inheritance. Another method of acquiring real property is through gift. And gifts of property are complete when the deed is executed and delivered. So just because someone is given a gift of property, there still has to be, and in all of these, in order for the transfer to take effect, there has to be a deed of transfer that's evidencing the transfer of the property from one owner to the new person. And that deed is then recorded on the county register of deeds where the property is located. When we talk about gifts of property, gifts are revocable. Gifts are revocable until the deed is delivered. So if someone says, I'm going to give you Blackacre, okay, and then they change it and they never give you a deed, you don't own Blackacre, right? You only own Blackacre when they deliver to you a deed. That is what evidences the transfer. And a deed, a gift, can be revoked at any time until that deed is delivered. You cannot make someone, self explanatory, but you can't make someone give you a gift. However, and in the law, we will learn that there's always a however. However, you can make them be responsible for any expenses incurred based on your reliance on the gift. So if someone told you, I'm going to give you Blackacre, and you go out and you go and Blackacre is going to require, let's say, um, stable and with horses and a tractor and all those things. You have that conversation. It's in, you don't have the deed yet, but you've had those conversations with the person. You go out, buy horses, buy a sign for the new property. You may buy a backhoe or something like that. You may buy a tractor. Those things, a person, if the person comes back and says, oh, change my mind, you can't have Blackacre, I'm going to give it to another person, then there's an argument that that in equity they can be made responsible for the expenses that was reasonably acquired based on the gift that you did not receive. And so another method, so we have the methods of acquiring property is through purchase, which is the most common, through devise or descent, which is basically a will, a trust, or maybe intestate succession if a person doesn't have a will, and then gift. All three of these are going to ultimately result in a deed, some type of deed, which evidences the transfer of the property from one person to another. And in the example of devise and descent, the deed would be prepared after the estate is closed. A gift, of course, it would be done when the deed is delivered and recorded. Another way of acquiring real property is through operation of law. And when we talk about operation of law, basically we're talking about adverse possession or through color of title. So those are the two ways that you can acquire property by operation of law. Adverse possession is very interesting because it is basically a taking of the land that belongs to another person after a statutory period of time without the owner's consent. So it is the taking, some people call it squatter's rights. It is the taking of the property of another, and you know that the person knows that they don't own the property. It's the taking through possession of the property for a statutory period of time. In North Carolina, that period of time, if it has not changed, is 21 years. So if a person stays on a property in a manner that is open, meaning open to the public, notorious, meaning the person is claiming a right to that property, it is under the claim of right, it is actual, it's hostile to the interests of the true owner, but the true owner has not come forth and said basically get off my property. And so it has to be, those are the some of the characteristics of property that must be present when you are a person is trying to acquire property through adverse possession. Open and notorious it can't be with the owner's consent, because if the owner gives consent, then one of the requirements is not met. Has to be open and notorious. It has to have actual possession of the property, not constructive. You have to have actual possession. It must be continuous. It must be exclusive. Okay, it must be exclusive. Okay, the adverse possessor cannot share the use of the land with its title owner. If the adverse possessor shares the land with the title owner, then there's an argument to be made that they were just some type of tenant, okay, or something like that. And so then the other way is through color of title. Okay, so you have acquired by, when we talk about operation of law, we have adverse possession and then color of title. What is color of title? Color of title is when a possessor has documentation that there has been an actual transfer of the land, but that the documentation may have been forged. right? So the distinction between having property by adverse possession versus having color of title is that with adverse possession, the possessor knows that they don't have a deed of to the property. They know that they don't have ownership of the property. But under color of title, there's been some type of fraud or something, and the possessor actually has a deed in hand that shows that ownership was transferred to them. Okay, and the deed may be defective. It may have been forged. Um, they believe that they own the property free and clear of all others. They believe that based on the documentation that they have, that they are the true owner of the property. And so the statutory time period for ownership under color of title in North Carolina is 7 years. But in any other state that you are working in, you will need to look up the statutory periods of time for both adverse possession and a claim under color of title. All right, so we've talked about the different type, what property is. We talked about the different types of property. We've talked about classifications of property. We've talked about some major characteristics of property. So now let's talk about the different estates and tenancies in property. The estates and tenancies in property. And these estates and tenancies will only relate to real property. That's what we're going to be talking about moving forward, right? So it is an estate and a tenancy which deals with the manner in which the possessor is taking possession of the property. What are they getting as a result of acquiring this property? Whether they acquire the property through the deed of transfer or whether there's a lease agreement which gives them certain right to use the property for some defined period of time in the contract. Estates and tenancies deal with the nature, extent, and duration of a possessor's interest in the land. It's going to deal with the nature, the extent, and the duration of a possessor's interest in the land. Whenever a person acquires real estate, real property, the person is going to get an interest in that land and any improvements on it for some defined period. If it's a leasehold or if it's a freehold, it's for an indefinite period of time. You must understand the type of estate and tenancy you are acquiring and which is identified through your transfer documents. So it's really important that we each individually understand that, but it's also communicated to clients. What type of interest are they acquiring when they get this real estate, when they get this real property? And so the first estate is a freehold estate. Okay, a freehold estate is an estate for an indefinite period of time. It is an estate for an indefinite period of time, and that is that means that there's no 5 years, 10 years, 1 year, 12 months. It's for and you get those when a deed of transfer is done, some type of deed. On the flip side or contrary, you have a leasehold estate, which is an estate for a period of time that is specified in the transfer documentation. A period of time, and the most common type of leasehold estate is a lease, some type of lease agreement where there's a contract involved in terms of the transfer of the estate for a period of time. So freehold estates, there are different types of freehold estates. The most common type of freehold estate is called a fee simple absolute. This is the most common type, and this is really the most preferred type. Okay, this is the most preferred type. It is the highest and best estate an owner can have. Basically, when a owner is given a fee simple absolute, they are transferred all of the interest in the title. They have those the five unities that we talked about a little bit earlier. The right to disposition, the right to possession, all of those, right? The owner, when you have a fee simple absolute, the owner is entitled to the whole estate without limitation or condition. They have unlimited power to dispose of the property during their lifetime, as long as they own that property. The property owner can also convey the property without any type of limitation um, on them in their ability to convey it, and they can convey the property with conditions on that property. But if there are any type of conditions on the property into when the property is transferred, it has to be stated in the words of conveyance. Okay, if there's any limitations on transfer, if the owner of the property is placing any type of limitations on that transfer to the property to another person, it has to be stated in the words of conveyance. And these are called when a fee simple owner that owns property in fee simple absolute transfers property, but there are conditions on that transfer. Those are called defeasible estates, meaning they are conveyed with condition. They are conveyed with conditions attached to them. Very important for you to look at your book so you can understand the different types of defeasible estates, the different types. And I would suggest that you create a chart because it'll make it easier for you to try to understand the differences between these. So defeasible estates are estates that are conveyed with condition. They start off with a fee simple absolute. Then the owner of that fee simple then transfers the property to someone else with condition. Okay, the first type of condition is a fee simple determinable. Okay, and it's important to look at the words of conveyance to know what type of condition has been placed on that property. So fee simple determinable, a common conveyance language would be as long as, or with the possibility, and it always comes with the possibility of reverter. Okay. Um, Fee simple is state that will terminate automatically upon the occurrence of a condition or event. When you look at a fee simple determinable, it is going to automatically terminate if something happens, right? It's going to automatically terminate if whatever the condition is happens. So, for example, A has possession, A has Blackacre as long as the land is used as a school. Example, that's a fee simple determinable. If the owner of Blackacre decides, I don't want to operate the school anymore, I'm going to tear down the school, and I am going to build a fitness center, right? Well, if that happens, then the condition will have happened and the property will automatically revert to whomever. So the reverter in that, the words of conveyance would be to A as long as the school is used for as long as the property is used for a school. And if not, then to B. Okay, in that situation, B is who would get the property. They're the reverter. They're the person who's going to get the property if the condition happens. If if it is left without a person there, it would automatically go back to the original person who transferred the property. Another type of the okay, so let's go back to the fee simple determinable for a minute. Okay, the event that's going to trigger the reversion is going to be stated in your words of conveyance. Your ownership is going to automatically end upon the occurrence of the event or condition. The grantor, who is the person that gives the property or transfers the property to the other person with the defeasible estate, is going to retain a future interest in that property unless they have a reverter identified in the words of conveyance. A defeasible estate or a fee simple determinable can be inherited, and it can also last forever as long as the event doesn't happen. So as long as the property is left as a school, then the person can own, or the person in his or her estate can own the property in infinity. But if the condition or the situation ever happens or changes, then either the reverter will get the property automatically, or it will transfer to the estate of the person who transferred the property initially, if that person is deceased. Okay. Um, Fee simple on conditions subsequent. Fee Fee simple on conditions subsequent is a fee simple estate in which the grantor has the power of termination. They have the power of termination. Does not mean that termination is automatic. Upon the occurrence of a condition or event, they have the power to terminate. Upon breach of the condition, the grantor has the right to enter and retake the property, right? And there's an action that has to be done to do that. Unlike the fee simple determinable, where the property is going to automatically go back to the grantor, with a fee simple on a condition subsequent, there has to be an action. The grantor has to actually take steps to retake the property if the condition happens. Okay, they have to take steps to retake the property if the condition happens. Upon breach of the condition that's stated in those words of conveyance, the grantor has the right to enter and take back the property. An example of a fee simple on condition subsequent would be, this is words of conveyance, to Y and her heirs on condition that no drugs are sold or used on the premises. To Y and her heirs on condition that no drugs are sold or used on the premises. If, in that example, if Y or her heirs ever allow drugs to be used on the premises, then the grantor, original grantor, or the grantor's heirs, if the grantor is deceased, will then have to take action through the court to re-enter and take possession of that property. They will have to take an action. Fee simple determinable is automatic. Fee simple subject to conditions subsequent, there has to be action to take the property back. And then you have a fee simple subject to executory limitation. This is an estate that ends when a specific condition is met and then transfers to a third party. This is an estate that ends when a specific condition is met and then transfers to a third party. The interest does not revert to the grantor. If the condition happens, it's going to go to a third party. Okay, example, X gives Y an estate in land so long as no drugs are brought onto the property, in which case the property will go to Z. So you see the difference in the words of conveyance. It clearly says what's going to happen if the drugs are sold on the property, right? The first part of it is a fee simple on condition subsequent, but when you add that additional language, it's going to automatically go to another person if the condition happens. The third party must be named in order for the fee simple subject to executory limitation to be proper. The third party who's going to acquire the property has to be named in the words of conveyance. Another type of freehold estate is a life estate. A life estate occurs when a grantor conveys property to a grantee for a period of time that is measured by someone's life. It is measured by someone's life. Now, the reason why a life estate is not a leasehold estate because the length of someone's life is still indefinite. You don't know when that life is going to end. So it's still indefinite, right? It's still in an indefinite period of time. So when you have a life estate, the grantor is going to retain a reversionary interest in the property unless they name a person. So an example of a life estate would be Blackacre will go to X for life, then to Y in fee simple absolute. So that's how a life estate is created. Okay. It is, you have a measuring life, which is X. Once X passes away, then that property is going to go to Y in fee simple absolute. That's an example. The owner of a life estate has the same rights of use, possession, and exclusion of the property. They just do not have the right to dispose of the property. No rights of disposition. Okay, when you talk about a life estate, you can have a life estate per ultra V, which is a life estate that's based on another person as the measuring life. And then another important point about life estates is that a holder of a life estate cannot commit waste on the property. They must upkeep the property. They can't, mess up the value of the property by lack of care or do anything to reduce the value of the property. So next, let's talk about leasehold estates. What is a leasehold estate? A leasehold estate is a legal term for property that is transferred via some type of rent or lease agreement. It is an estate for a determinable duration that does not grant any ownership rights in the actual property. Whenever you have a lease, it does not give any ownership rights in the property, no right to dispose of the property, but it does give the owner the right to use, to possess, and to exclude others from the property during their tenancy. There are different types. You have an estate for years, which sometimes is referred to as a tenant for years that ends at a fixed date. An estate for years where, like, let's say you have a 12-month lease or a 24-month lease. Okay, it continues for a designated period and automatically ends on a fixed date unless the parties enter into a contrary agreement. If it is longer than a year, then it must be in writing. Any agreements that are longer than a year for leases have to be in writing because of the statute of frauds. Then you have tenancy from period to period. It is a tenancy that continues for successive intervals until one party to the agreement provides to the other party notice of termination. So that could be like a month-to-month lease. That's a tenancy from period to period. The disagreement can be expressed or implied. It can be in writing or can it be implied based on action. This is a type of tenancy where the tenant automatically continues to occupy the property for successive periods, such as month to month, unless the tenancy is terminated by notice of either party. Then you have a tenancy of will. A tenancy of will. It is a tenancy that usually begins as an estate for years and then converts to a tenancy at will once the estate for years expires. Okay, this can be terminated by either the tenant or the owner. And then the tenancy at suffrage. This is a holdover tenant. Okay, this is where a tenant remains in the lease premises after the tenancy ends, and the lease has expired, and they remain in the tenancy. They remain in the property without the landlord's consent. All right, so there are different methods of holding title. So we talked about the different types of estates, the two types of estates being the leasehold estate and the freehold estate. Now let's talk about the different methods of acquiring title to real estate. One is individual ownership, which is one person holds title to real property in his or her own name as a single owner. And commonly, the ownership of the property is transferred by deed. This individual owner has the right to use and ultimately dispose of the property in any manner that he or she sees fit. When you're looking at and considering the methods of title holding, how the title is held, you also want to look at the words of conveyance in the deed. Title can be held in the name of an individual owner, but it can also be held in multiple owners, and that's what we're going to talk about here. Each method of concurrent ownership occurs with different rights being given to the owners. So you have individual ownership of property, then you have concurrent ownership, meaning more than one. With individual ownership of the property, that person is liable again for all real property taxes, any type of assessments or anything that is associated with the property, and any claims that attach to the property that they own and will attach to them as individual owners of the property. You also then have concurrent ownership of property, concurrent or joint ownership of property. This is ownership in which two or more individuals own an interest in real property. Co-owners share rights of possession. They share rights to any type of rental income, any expenses, and in the expenses for improvements and the expenses for any waste on the property. The distinction between the types of concurrent ownership is very important when you're considering inheritance and the disposition of rights of ownership. So the type of concurrent ownership is very, very important because they do have different rights that attach with each. Most specifically, the rights are regarding inheritance. So the three types, are tenancy in common, joint tenancy, and tenancy by the entirety. So you have tenancy in common, joint tenancy, and tenancy by the entirety. Tenancy in common is the most commonly used method of holding title, or the most common ways that individuals, more than one person, own title or get title to property. With a tenancy in common, if there are no clear words of conveyance in the deed, that will be the default. That will be the basis of holding ownership of the title. Tenancy in common allow multiple owners to own the title, and they can own different percentages of title in the property. For example, you can have Mary, Jane, and Sam all own property as tenants in common, one piece of property as tenants in common. Sam owns 50%, Sarah owns 25%, and Jane owns another 25%, for example. So with tenancy in common, you can have multiple owners that own the property with different percentages, and they can even acquire the property at different periods of time. The disadvantage of tenancy in common is that there is no inheritance rights that automatically pass with the property. So what that means is that when one of the owners of the property pass away, then that property would pass in accordance with his or her deed. Okay. You can have any number of persons, any number of owners to that property. They don't have to acquire it at the same time in the same instrument. It could be different deeds at different times. They may own equal or unequal shares in the property, but it does not concur or transfer any type of survivorship rights. And survivorship rights deal with what happens when the person passes away. Any person, each person, when you have a tenancy in common, that person can sell or devise. When I say devise, I mean transfer by will, by trust document, their interest in the property. Okay, at any time without breaking or destroying the tenancy in common. Unlike with the joint tenancy, the tenancy has to be created in the same instrument, meaning the same deed. There has to be the same percentages of ownership, and it does include the rights of survivorship. What that means is that when one of the joint tenants passed away, their interest will automatically be shared by the other joint tenants. Um, if a one of the joint tenants decides to sell their interest in the land, that breaks the tenancy. So they're very important distinctions between the joint tenancy and um, the tenancy in common. Disputes between co-owners can be resolved through, when you're talking about a tenancy in common, if there's a dispute between one of the tenants in that instance, it can be resolved through partition, which is judicial breaking up of the property. Okay. A joint tenancy is when you hold an estate in land or property jointly by two or more parties with the share of each passing to the others upon death. That is what a joint tenancy is. Each co-owner has the right of survival in the undivided interest of the other's co-ownership. One advantage of a joint tenancy is that it does avoid probate. And for those of you all who are taking wills and trusts, if you may have already taken it or you may be taking it this semester or want to come, trust is probate is very expensive. And so by creating a joint tenancy for property, it does avoid probate because when one of the joint tenants pass, their interest in the property automatically pass to the other two joint tenants. There is, when you have a joint tenancy, there is the presence of those four unities that exist. It has to be unity of possession. They all own, they all have equal right to the property. Unity of interest. They all own the same interest in the land. So it can't be like the previous example I gave where one owned 50 and the other 25%. Unity of time in terms of the time and title. They have the same type of title. They have, and the interest was created at the same time. It must include all of those to be a joint tenancy. And so when you are, again, when you're thinking about whether how they hold title, you want to look at the words of conveyance. So it could say, to Sally, Sam, and Jane as joint tenants with rights of survivorship. If it just says to Sally, Jane, and John with nothing else, then the court is going to infer that a tenancy in common was the intent of the parties. So a major distinction between the joint tenancy and the tenancy in common is how it's created, the amount of ownership interest, and the rights of survivorship. Remember that rights of survivorship do not pass with a tenancy in common. But tenancy in common will be the default if it is unclear what type of tenancy was intended by the parties and the words of conveyance are not there. And then we have the tenancy by the entirety. And a tenancy by the entirety is the method in which people who are married acquire property in the state of North Carolina. Not all states have tenancy by the entirety. Some states, married people hold property as tenants in common. I'm sorry, not tenants in common. I'm sorry. They hold property, they're community property states. But North Carolina does have tenancy by the entirety. It is a form of joint ownership that occurs when a property owner is husband and wife, unless there is a free trader agreement in place, which says that the property that is acquired during the marriage is separate property. Okay. It occurs only when the property is owned by a husband and wife, and the law says, and it treats the ownership as each of the couple owning 100% of the property. So what that means is that no person, neither person in the marriage can sell the property or otherwise dispose of the property without the consent of the other. And when the other spouse passes away, that their interest is going to automatically go to the surviving spouse. So A and B are husband and wife. B decides that upon his death, he's going to leave his interest in the marital home to his cousin. That's not proper. Okay, that's not proper. The only way that the cousin would be able to acquire the property is if wife also agrees to that transfer. Neither spouse has an individual interest in that property, and they can't convey it individually. They have to have the other person's agreement. Neither party can mortgage or convey any right to the property without the consent of the other party. Divorce will terminate the tenancy and convert it to a tenancy in common. So if the parties divorce and if there's still marital property that has not been resolved as part of the divorce settlement, that property is going to become property that's held as tenants in common unless they do something. What else could they do? They could decide to get a new deed and own the property as joint tenants. But that generally doesn't happen in situations like that, but it can. So the important thing to note is that divorce is going to break the tenancy by the entirety, and then as the default would then kick in, and they would own the property as tenants in common. In addition to into individuals owning property, whether that be individual or concurrent ownership. Business entities, of course, can own properties as well. Um, the title to the property is based on the laws of the state and how the business was organized. A good rule of thumb for that is to look at the Secretary of State's website so you can see how the business was organized. And so the book goes into the different structures of ownership, but the basic thing for you to understand is that business entities can own property as well. And there are different, based on how the business is structured, will determine how the deed of conveyance is structured as well. And so the final thing that we will talk about tonight is other ways that interest in property can be acquired. They can be acquired by dower, and that's a common law principle. That is something that's really old school, that's not really followed anymore. But dower is a widow's share for life of her husband's estate. That's what dower was. Okay, there's no right to transfer until the husband dies. So the wife gets no interest or right until the husband dies. And the rights terminate at the death and can pass to heirs if the wife dies first. Okay, so it's going to terminate at death and can pass to the wife if to the heirs if the wife dies first. So if the wife dies before the husband, then that the wife's interest can transfer to the heirs if she dies first. Courtesy. Most states have abolished the concept of both dower and courtesy. Okay, and courtesy is a common law right of a husband to the estate and property rights of his deceased wife. A lot of this one is connected to if they have a child that was born of the marriage. And then we have the concept of community property. Some states, as I forestated, rather than equitable distribution, they are community property states where the courts will look at when the property was acquired. Was the property separate property, meaning property that was acquired by one of the spouse prior to their marriage? Or was the property acquired during the course of the marriage? If the property was acquired during the course of the marriage in community property states, when the court considers the division of property, they will consider that property community property and then continue with an analysis to determine the percentages that each should get, which is usually, sometimes, often 50-50. Okay, so when you look at separate property, it's generally property that is acquired by the spouse prior to their marriage. However, any income that is generated from the property during the marriage may be marital assets. So that's something that you'll learn in family law. Community property is going to be all property, not just real property, but all property, both real and personal, that is acquired during the marriage by either spouse. Okay, so when you think about property ownership for married people, you think about community property and tenancy by the entireties. All right. And so then this is homestead property is still in existence. This is another way that folks acquire interest in property. And there is some statutory guidance on this. This is the primary dwelling house, and surrounding land owned by the family or the head of household. Okay, North Carolina specific homestead exemption excludes from property taxes a portion of the appraised value of the permanent residence owned and occupied by North Carolina residents that are age 65 or older, or those that are totally and permanently disabled whose income is below a certain threshold annually. And in 2023, that amount was $36,700. So that all of that comes under the homestead protection in the state of North Carolina. And so that brings us to the conclusion of our material for chapter 2. If you all have any questions about anything that was discussed in chapter 2, and I'm thinking that probably some questions may come in the area where we talked about the different types of interest in land. And there's some formulas. We can definitely talk about them, and we will deal with those in exercises to come. Otherwise, I hope that you all, and then what I need you to do when you watch this video is I need you to send me an email attesting that you have watched the video, at what time you completed it, for attendance purposes. The honor code does apply, and so do expect each of you to watch the video. I will be back online live on Tuesday. Otherwise, have a good evening and a good weekend. Thank you so much for your time and attention.